A family law judge might hear thousands of cases over their career, but a child only experiences one childhood. Because children absorb the long-term damage of high-conflict litigation, parents and advocates are under immense pressure to fix the systems overseeing these families. Many reach for the most immediate tools available: public outrage, systemic accusations, and adversarial attacks. Mapping these advocacy styles reveals a consistent pattern. High hostility approaches trigger institutional defensiveness. Outrage advocacy plots firmly in the quadrant where systems lock down rather than evolve. While adversarial attacks can offer an emotional release for an aggrieved parent, they rarely result in better protections for the child. Success requires a pivot toward strategic advocacy. Most family law judges entered the profession to help families, not to cause harm. Understanding this intent is the first step in reaching them. These judges operate within survival systems defined by massive caseloads, constant political scrutiny, and compassion fatigue. Constant exposure to high conflict dynamics and limited time with each family creates a high risk of secondary traumatic stress for the person on the bench. To cope with this stress, many judges rely on emotional detachment. They begin to prioritize procedural efficiency and conflict containment over the messy nuance of human healing. When systems produce harmful outcomes, it is often a result of these survival mechanisms rather than individual malice. Attacks on a judge's character fail to address the underlying systemic pressure. Reformers who use accusatory messaging, labeling a system evil or a judge abusive, trigger a predictable biological response in the listener. The human brain interprets these messages as a threat, immediately activating ego defenses and institutional loyalty. In this state, the brain prioritizes defense, dismissing arguments to preserve authority. Transitioning to reflective questions, asking how to detect invisible trauma, creates a new entry point. These inputs bypass protectionism, tapping into the judge's original motivation to examine root causes instead of just managing conflict. Adopting this reflective approach requires advocates to put aside revenge-focused narratives and focus on the ethical translation of trauma. It is a difficult shift that trades immediate catharsis for long-term influence. A judge who feels emotionally safe enough to reflect becomes more open to change. Systemic evolution begins when the environment shifts from one of blame to one of invitation. The physical courtroom typically captures only the most volatile fragments of human behavior: angry outbursts, manipulation, and adversarial tactics. The judge does not see what happens at home: the panic attacks, the splitting identity, or the chronic stress of living in prolonged conflict. Relying on abstract legal arguments often fails to bridge this gap. Fragments of behavior seen in court rarely convey the full scope of a child's experience. Human stories demonstrating specific attachment disruptions resonate deeply. They provide the necessary context a judge needs to understand the child's entire survival ecosystem. While legal statutes and procedural arguments may fade from memory, a judge is much more likely to remember a story that centers on a child's long-term developmental health. Shifting away from outrage requires replacing subjective complaints with objective institutional data. Tracking specific child-centered metrics makes it difficult for a court to dismiss concerns as part of a high-conflict personality dynamic. This approach focuses on measurable patterns: the frequency of repeated litigation, disruptions in a child's therapy, and the timelines between allegations and investigations. Gathering metrics involve pediatricians, local school educators, and dedicated social workers to build a composite view of the child's environment. What gets measured becomes harder to ignore. These data points provide a common language for the court to address the root causes of conflict and provide a clear path for accountability. Many judges have never received deep training in complex trauma, coercive control, or psychological maltreatment. Lived experience panels, where judges hear directly from adult survivors and trauma specialists, can shift their emotional understanding of the cases they decide. This knowledge supports a new trauma-informed structure. It includes early trauma screening, formal child impact assessments, and ongoing education on the dynamics of family systems. This structure anchors the court's focus on the child's history, rather than the competition between litigants. The priority shifts toward protecting the child's developmental stability. Real reform happens when empathy becomes operational. The court's primary function evolves from merely processing conflict to actively safeguarding a child's environment. For parents, protecting a child means setting aside the impulse to publicly humiliate the court. Effective advocacy requires reframing every argument around the child's nervous system and long-term well-being. Professionals can strategically introduce trauma education and data transparency into the legal process. This builds a foundation for better decisions without triggering institutional defensiveness. Successful advocacy must be multidisciplinary, evidence-based, and focused on prevention. Use this criteria to audit your approach and ensure it encourages judicial reflection. Equipping the system to recognize invisible trauma allows courtrooms to function as a shield for childhood, rather than a processor of conflict. The goal is to help these systems evolve before more children inherit preventable trauma.